NBC's Gabe Gutierrez is reporting from the White House. MSNBC legal analyst, former U.S. attorney, and Michigan law professor Barbara McQuade is here as well. Barbara, what I've been able to get through in this, the judge did not mince words in his response to the government. Let me read just one part of it. The Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it. To permit such officials to freely annul the judgments of the courts of the United States would not just destroy the rights acquired under those judgments, it would make a solemn mockery of the Constitution itself. What else stands out to you in this order, and what do we need to know about it?
Well, the judge wasn't going to let this go. This was the hearing where he conducted a hearing. He said if there are planes in the air, they must turn around because none of these people has had the due process to which they are entitled, notice, and an opportunity to be heard. And the government hedged and changed its story many, many times. And now the judge has put together a very detailed timeline that makes it clear, according to the judge, that there was a willful violation of his order. He said, don't remove anybody. A plane took off after he issued that order. And so now he finds this willful violation. He said he's going to give the government an opportunity to correct its error by giving these men the opportunity to contest their removal. But if they fail to do that, he will refer it for prosecution, criminal prosecution for criminal contempt.
So there are two possibilities here. One, as I understand it, as I'm looking at the order, which is only a couple of paragraphs, as opposed to the much more lengthy details you talk about. First of all, if they opt to purge their contempt, he wants them to file by April 23rd. But then the second one, for me, is really interesting. If defendants opt not to purge their contempt, they shall instead file by April 23rd declarations identifying the individual or individuals who, with knowledge of the court's temporary restraining order, made the decision not to halt the transfer of class members out of U.S. custody. In other words, he's saying, who made this decision?
Yeah, absolutely. One of the things that the lawyers have tried to do here is to evade accountability by saying they don't know who made these decisions. And that may very well be the case. It may be that the government officials are sort of hiding behind the legalese and not telling the lawyer who the specific individual was who made the decision. But that's the person that Judge Boasberg is going to want to prosecute for criminal contempt. Who was the person who knew that this order said you must stop and said, to hell with it, send them anyway? There's somebody out there who made that decision, and Judge Boasberg is telling the government, cough him up.
Dave, is there any response from the White House yet?
Hi there, Chris. No response yet from the White House, but we expect that to come in the coming hours. Certainly the Justice Department probably looking over this ruling. But Chris, the White House over the last several days has become increasingly critical of the federal courts and what they see as critics within the media themselves and also Democrats. And they've tried to make this argument that these are violent gang members being sent overseas back to El Salvador, and that the courts do not have jurisdiction over foreign policy. That's the argument that they put forward time and time again. Certainly the judge with this court filing disagrees with that and says there's a great danger here of thumbing your nose at the Constitution, and also saying that the court doesn't reach such a conclusion lightly or hastily. Indeed, it has given defendants ample opportunity to rectify or explain their actions. Now, Chris, this also dovetails with another case that a specific case that has been in the news over the last several days, that of Kilmar Abrego Garcia, who was deported to El Salvador yesterday. A separate judge said that she wanted to see the government turn over evidence and depositions within the next 2 weeks. So basically, Chris, this it comes as the federal judiciary is clashing directly with the executive branch and has major implications going forward. Again, we're waiting for a response from the Department of Justice, from the White House, to see what their next move is. We don't have it as of yet, Chris.
All right. I know you'll get to us if something pops up on your phone, Gabe, so stand by for us. I also want to bring in MSNBC legal correspondent Lisa Rubin. Lisa, for decades, there have been arguments, fights in Congress with presidents, certainly at town halls even, about immigration. Immigration reform has been talked about. They've never reached it. I don't know that we have ever seen an escalation on all of those fronts, the political front, the American voter front, and of course now with the courts, as we're seeing here. So let's
the last time I remember it is, in my lifetime, is thinking about the Elian case.
That's Elian Gonzalez.
Correct.
Who was a young boy that the question was, could he be brought back to Cuba?
Correct.
I covered that story. I was down in Miami for quite a while.
Yeah, and that story in the 90s really captivated the country in terms of our attention on a particular immigrant. I can't recall any other particular immigrant story captivating the country and really holding everybody's attention nearly as much as that one until now with Kilmar Abrego Garcia. But of course, this is also some context for that debate that we're having there, because this is about one of the larger issues of the government's compliance with court orders and where the balance of power lies between the various branches. I think it's particularly significant, Chris, that this order was filed today on the 16th of April. And the reason that matters is because Judge Boasberg had also told the parties in the wake of the Supreme Court's vacating his temporary restraining orders, you need to tell me by April 16th whether you think there's anything left to be litigated before me, clearly expecting perhaps that the plaintiffs are going to tell him, you know what, we're actually done before you because the Supreme Court has said we need to litigate the rights of these folks in the courts where they're being held. Right now, there's a pending class action in New York, another one in Texas. Given that there may not be any further proceedings before Judge Boasberg, he wanted to set this line in the sand. It doesn't matter to me that the temporary restraining orders were vacated by the Supreme Court, because for the period of time that they were in effect, the willful disobedience by the executive branch is so extensive that I cannot tolerate it, nor can the Constitution of this country.
Gabe outlined some of the problems that the federal government have argued, but there's another one. One of the things that they've said is, this is a lot of the stuff you want, Judge, is top secret. The judge says that he is skeptical that information related to these flights somehow qualifies as state secrets. So is it clear what the government would even need to do to make that case?
Well, he has offered them an opportunity repeatedly to go into a classified facility with him and present him with that argumentation. He has repeatedly explained to people, I have top secret security clearance in my capacity as a federal judge in D.C., but also because I was a member of the Foreign Intelligence Surveillance Court. You can come to me. We can go into a skiff in this courthouse, and you can tell me all of the things that I have ordered you to tell me in private without disclosure to the plaintiffs, much less to the public. And the government has repeatedly disclaimed that. The idea that Judge Boasberg himself is not to be entrusted with that information is in part a tell that there isn't anything all that secret to be revealed, certainly not anything that would justify the invocation of the state secrets privilege here.
So, Barbara, break down the stakes here. Break down the stakes for the federal government. Break down the stakes for the Constitution.
Yeah, this is, people talk about a constitutional crisis, I think maybe rather loosely, but the idea that the executive branch would disobey a court order is really just a red line that we have not seen crossed before. Judge Boasberg here, even in this instance, though, is giving them a couple of chances to get out from under it. One, by remedying its failure to comply with this order already. That could be the first step. If they continue to disobey, though, what he says is he is going to refer it for criminal prosecution. He is going to ask the Department of Justice to prosecute it. And if they refuse, he says he will appoint his own lawyer to prosecute the case. So I think the stakes are very high for the Department of Justice. I don't think he's going to back down. I think if they refuse to comply, he will refer this to a private lawyer to prosecute somebody at the Justice Department. And I think that if the president or the executive branch continue to disobey this order, really the only remedy left at that point is congressional oversight all the way up to potentially impeachment.
I know you were nodding pretty vociferously when you heard what Barbara had to say.
You know, Barbara was talking about the potential of a criminal referral to the Department of Justice, and if the Department of Justice doesn't want to take the case, as we would imagine, given their posture thus far, they will not want to if we get to that point.
I mean, so are we talking about like the government potentially prosecuting itself?
Well, that's how criminal contempt usually works, and that's actually how it's set up in the federal rules of criminal procedure. But there's another option available in those rules, as Barbara was referring to. If the Department of Justice declines to prosecute a referral or recommendation of criminal contempt, the judge has an option to essentially appoint a prosecutor of his or her own choosing, somebody who is not currently a member of the Department of Justice. There is historical precedent for this. In the Southern District of New York, here in Manhattan, there was a lawyer named Stephen Donziger who was referred for criminal contempt. The Southern District of New York's U.S. Attorney's Office declined to take that case up, and the judge in that case appointed a former prosecutor in the area who's in private practice to handle that contempt proceeding herself. His conviction, Chris, on criminal contempt was upheld by the Supreme Court. So you're going to hear people say today, this guy is lawless. He's even suggesting appointing his own person to prosecute contempt if the Department of Justice refuses. And I just want to make clear to you and our viewers, that's something that the law expressly allows and for which there has been precedent that has been upheld by the United States Supreme Court itself.
Critically important conversation. Barbara McQuade, Lisa Rubin, thank you for jumping in on the breaking news.